apologies, it's now recording.
Bingo. Thank you, sir.
You're welcome. Thank you.
Mhm.
All right. I guess at this point, I guess we can move into the monthly issue tracking.
Right, and you see, I received 4 complaints. Um, None of them met the prerequisites for the being addressed by the board, and I'm recommending that each of them be closed for the reasons stated in the report.
Does anyone have any questions pertaining to the tracking report? All right. At this point, I guess we can move on to the budget report. Oh, excuse me, Mr. Richard, did you have your hand up?
Yeah, I did have one question on the fourth one, which I'm sorry, I didn't get myself unmuted in time. The fourth one about somebody, I assume this person's in the city, complaining that a city employee was harassing the person or neighbors. Do we have any idea what level that city employee is? Is it a management level employee, a line level employee? Just that one little piece of information, I think would add to my comfort on dismissing that one.
Yes, I think it was a line level.
Okay. So not somebody in a supervisory or management position.
Not that I'm aware, no.
Okay. Thank you.
All right, that takes us to the budget report.
The budget report, bottom line is we have an available budget of $137,790. Since last we met, we paid a court reporter $1,168. We made two payments to Attorney Reed, our board attorney, one in the amount of $3,138, another in the amount of $1,975. We made a couple of payments to outside counsel, Attorney Menace, for $2,775 and for $625. You see a number of routine bills that you see each month. You see a payment for laptops. When we went remotely, I purchased laptops for Lucy and I. The total for both laptops was $1,650 plus $84 for 2 cases. And that has been tremendously helpful to both of us. I also signed up for COGO, which is an international conference on ethics. Traditionally, we have been involved with that conference, and I did a little research. I believe one city attorneys is also engaged with that conference. And those are the purchases, other than things like supplies, those are the purchases that we have made.
Any questions from the board concerning the budget report? I guess at this point we can move to public comments. Mr. Floyd, would you be so kind as to read the public comments into the record?
Yes, sir. We have 2 public comments on 2 separate agenda items. They're both from Peter Butson from 1628 Woodgate Way. First is agenda item 11, Ethics Office Audit Report by Outside Agency. His statement regarding the Ethics Office Audit Report by Outside Agency, while I personally have little to no confidence in the former ethics officers, I am truly appalled that she so blatantly avoided oversight for her time cards and unsupported disbursement authorizations, including one to herself without any documentation for $391.01. Frankly, I am surprised that the audit found the Ethics Office in compliance. I strongly encourage board to adopt the recommendation of Moore Stevens, Lovelace, PA, MLS. And we have one other. This is for agenda item 12, selection of at-large board member. Regarding selection of the at-large board member, while many of the applicants are obviously well qualified in their professions, few appear to have direct experience and training in ethics. Possible exceptions include David J. Alcorn, who has experience as an inspector general, Julie Taylor Fisher, who has experience with Medicaid fraud investigations and an apparently strong background in communications. William DeAngelis, cover letter emphasizes his ethics experience and related experiences in the law. He appears to be the only applicant to specifically address ethics. Of course, my review is limited to reviewing the applications. I am not personally familiar with any of the candidates, with the exception of John Paul Bailey. Interviews, background checks, and references provide a better understanding of a candidate's suitability for the position than a resume. Thank you for your consideration. Those are all the public comments that we have received.
Mr. Chairman,
You're recognized.
a comment on public comments. Two things, actually. One is I've gotten a couple of calls between the time that the public comment period closed and the beginning of our meeting, and I'll pass along those issues as we get to the items. The other is, as we move forward, if we're going to continue to do meetings like this online, I think that I think we need to find a way to be able to accept comments during the meeting. And I'll give you a very specific example. We started the meeting today with Mr. Reed, I think very aptly, having drafted something for us moving forward to meet in this format and addressing issues related to our own bylaws. That was not something that was on the original agenda. So somebody watching our meeting who might have wanted to comment on that would have had no way to comment on it by I think it was an 11 o'clock deadline. So I would like to propose that moving forward, we have some opportunity for people to be able to comment during the meeting.
I would agree, and I think there's a way that we should be able to work out a period where the chat option should be open, even if we have to have a set time frame for that. I know we don't want to have it open. I wouldn't want to have it open the entire meeting because it would help us keep some decorum with the meeting. But if we do have our designated times, like in this time period moving forward, if someone could control the chat, Mr. Floyd or myself, I think that would be an excellent idea, and it lends to the transparency that we like to have.
Mr. Chair?
Yes.
Just so you're aware, the public seeing the streaming media option, they're on a different platform than we are. But it would be good if somebody were monitoring emails, which hopefully would go to the ethics email rather than to Mr. Herring. Then perhaps Lucy could read them, any later ones that come in. I almost commented at the time that we accepted the resolution. There is an item, I think section, I forget the section, the part on public participation procedures. There's a line that said comments will not need to be read public into the records during the meeting. The way that's worded, that's fine. It won't need to be read, but I strongly applaud Mr. Floyd going ahead and reading those comments. It's important to have the public comment during the meeting. I know that's a big weakness with the city commission meetings that have been online this way, And I know a lot of people that are going to be complaining to the city commission. They're not feeling that the public is adequately participating the way it is. So it'd be good if we had some kind of somebody monitoring the emails coming into the ethics office while we're online and reading those if possible.
So, Mr. Chair,
I think that's an excellent idea. Okay, Richard.
a technology question moving forward. I've done in the past some training using this particular platform with a lot of people online at any given time. Is there any reason the way that the city operates that we couldn't allow members of the public to just log in, just like we're logged in live during the meeting, be able to watch it on a computer or a tablet or even their phone with someone on our end, then because WebEx certainly allows you to mute people and unmute them and allows people to raise their hand at various points to make comments. That we couldn't have people literally in the meeting with us, just like we would have people in the room with us in a regular meeting. Just a technology question moving forward.
Mr. Chair,
Yes.
I am working with the City of Tallahassee, and I know that they are looking in. When they started doing this, they did not expect us, or this situation in terms of electronic meetings to last this long, but recognizing that there may be no end in sight, they're looking at better avenues for engaging the public. And so I'm in conversation with them on that. And we're hoping by the time we meet next month, we'll be able to offer something better.
Yeah, I think that would be great because I've been in situations where we were doing formal training for 30 or 40 people and who had employees of their own who were sitting in. So we might have 200 or 300 people on a WebEx, and down the side you can see all of those people, and all of them had the ability to raise their hands. And the people who were formally in the training were getting their required hours and such, but people who weren't formally in it, who might have a comment or be able to lend some additional information when one of the trainers maybe wasn't clear on a particular procedure, they had the ability to participate. It's a different situation than a public meeting like this, but I know that WebEx has some capabilities that would allow active, live, in the moment public participation.
All right, can we put, I guess, a small team together, 2 to 3 of us, to make sure we can work these particulars out before the next meeting, the next monthly meeting?
Are you looking for volunteers from the board?
I'd be glad to volunteer to participate since I have been involved in that kind of activity.
Mm-hmm. And I'm always good to do whatever I can without bringing my monkey wrench with me.
All right, that'll be fine. And just so I can learn more about it, I'll participate as well.
Noted.
All right.
Sorry that I can't. I'm sorry that I can't, but I've been I'm consumed. I'm traveling back and forth to Gainesville a lot, and I just hate to commit to something that I won't be around to be able to fully participate in. Please excuse me at this time. I hope this issue resolves itself soon.
I think we'll be able to get it resolved. All right. Do we have any more questions concerning, or any comments about the public comments? All right. We'll move forward to old business. I believe we had 2 items: status of broadcast of board meetings and the board recommendation to the city commission on lobbyists. At the last meeting, there was a discussion about conducting our meetings on WCOT, which required the use of the city chamber. Of course, we're in this COVID pandemic, so that has been put on hold. Mr. Floyd, I know he's supposed to continue that discussion with the city, as well as finding better ways to engage online. I guess this would be an example of that. Mr. Floyd, do you have anything else to add to those comments?
I don't, Mr. Chair.
All right. Are there any questions regarding our TV broadcast from anyone? The next part would be the board recommendation to the city commission lobbyist, Mr. Herring. Do you have a summary that you could provide for us addressing that, any revisions to that?
Yeah, well, I think Mr. Reed and Mr. Floyd can go over the proposal that's in front of us, but I just wanted to provide a little bit of background because this goes back a long way. Looking back in my notes, I found the issue of lobbyists and how lobbyists are handled by the city, who's classified as a lobbyist, going back at least to November of 2017. I know that we've had public testimony at least every 2 or 3 months for several years on the issue of lobbyists. I think the whole issue of lobbyist and lobbyist registration, how lobbyists' activities are made public, is something that falls squarely within the concept of ethics under the state law. And when we were back in 2019, when we were doing our kind of blue, or even late 2018, when we were doing our kind of blue sky list of all the things that we might think about, either for changes to our board policies and procedures, recommendations to the city commission for charter amendments, recommendations for ordinances, recommendations for city policies, that there were 3 or 4 places in there where lobbying and lobbyists were mentioned. When we finally came out with our recommendations, both for ourselves and for the city, we obviously took a pretty big bite. We did not do everything that was on the list that we had thought we might get to. And this was one, I think the proposal that's before us today is one of those things that we simply didn't get to because we had so many other bits of low-hanging fruit that we were ready to pursue. So I know that the Ethics Coalition folks have been very consistent about hoping that we would take this issue head on and do something concrete with it. So just so everybody knows that this is nothing new. It goes back probably a good 3 years in terms of board discussions. So you could go to any of your predecessors or your predecessors' predecessors on the board, and they would all say, oh yeah, I remember when we talked about that. So that's kind of my little bit of background.
Thank you. Mr. Reed, you like to add to this?
Yes, Mr. Chairman. So the issue that we discussed at the last meeting was twofold. One was the definition of lobbying. If you recall, I pointed out it was a little circular. It said a lobbyist is somebody who involves in lobbying, and lobbying is done by a lobbyist. So it kind of went around in a circle. So we wanted to provide a little more definition, and I think we wanted to also do our best to kind of close any loopholes that might exist. When is an influencer not a lobbyist? And I think the argument would be that an influencer would be a lobbyist, whether they were acting as a quote unquote lobbyist or a PR consultant or a grassroots organizer or whatever they may be. So when I drafted, I looked at some of the local governments around the state. Miami-Dade, actually, I felt had one of the best ordinances to model after. And I did take a lot from what they already had in place. Our existing ordinance places most of the emphasis on the act of lobbying and not as much on the definition of the lobbyist. I kind of reversed that, and my reasoning on that is that the subject is lobbyist registration. We require registration by an individual or an entity. So I felt that it was best to place the definition and define the activity around the individual and not just to define the activity. And I think that might work best. So if you look at the language before you on page 1, lobbying essentially means any communication by all persons, firms, or business entities acting as a lobbyist as defined by this section. Then that's where we end it. Now at lobbyist is where we flesh it out. And this is a very wide net. It's essentially, I think will cover almost everybody involved. And it's whether they are paid or not paid, a principal or an employee, and anytime during the decision-making process, whether to persuade, to pass, or defeat any particular issue. And then it's to encourage or influence. Now, we broke it into 3 groups that they would be encouraging or influencing. 1 would be members of the city commission themselves. 2 would be the city manager or any decision-making body under the jurisdiction of the city charter or the city commission. So that would include us as well. And then any employee pertaining to any action, inaction, or decision. So if somebody were trying to not go directly to the elected official, but go to their staff person, this would also encompass that as well. Most significantly, we didn't want to cast the net so broad that we infringe on anybody's right to petition their government and make it so burdensome. So anybody that were to testify as an expert witness before any of the commission or boards would not be required to register as a lobbyist. Number 2, which begins on line 52 of the language, I think would be somewhat relevant to us. If there's a quasi-judicial hearing and somebody were to behalf of somebody, they would not be required to register a lobbyist. The immediate example is if we were to conduct a hearing over a complaint against somebody who was within our jurisdiction, and they were to hire a lawyer to represent them before us, that lawyer would not be a lobbyist. They would be serving solely as a lawyer. Number 3 was the resident of the city, and they would not be receiving compensation or reimbursement for their appearance. And I think we wanted to be clear that if you are a resident of Tallahassee and you go to the city commissioner and say, hey, I'd like you to vote to lower garbage rates, that person, if the garbage rate is reduced, they would experience some type of financial gain through that. And we didn't want to include that person. We think that the person should be able to petition their elected official for something that only affects them personally. And I wanted to make sure we didn't accidentally cover that person. If somebody's representing a neighborhood association without compensation, they would be exempt. If they were being compensated to appear before the city commissioner or any other board, they would have to register. And then a not-for-profit solely for the purposes of requesting a grant. And then lastly was the city employee who appears before our board. We've had members of the city attorney's office from Tallahassee come and speak to us, or the city auditor's office. They're obviously acting in their capacity as a city employee. They shouldn't be required to register simply for that, so we exclude that. And then an independent contractor who is acting on the behalf of the city of Tallahassee, and that would be somebody like me when I went to the city commission to discuss our draft of the ordinance rewrite. I would not be required to register as a lobbyist since I was acting solely in my capacity as this board's counsel. I removed the language for lobbying firm because I think we get it covered under lobbyist, because lobbyist is expanded to be an individual, a firm, or a business entity. So that allows that to be broadened. An employee, we wanted to include also independent contractors. So it doesn't have to simply be an employee, but we brought it to anybody who's actually working on behalf and has some type of employment relationship. And then decision-making body is any body established by the city commission, but also by the charter. We're created by the charter. We're not created by the city commission. Other boards are created by the city commission. So this would have us included. And then there's severability and effective date. And this would be something that we could present to the board for their consideration, possible workshop. The second issue that we had discussed that I didn't address here was an item on, I think we discussed 2 calendars, whether somebody had 2 calendars, whether we wanted to document meetings that members of the city commission had with a lobbyist. And before we drafted any language, I wanted to receive some guidance from the board to ensure that we didn't go too far. One issue that I think it's important to discuss is the 2 calendars issue. I think in many cases, I think it would be responsible of a city commissioner to maintain 2 calendars. I think they should maintain an official business calendar, but they should also have a calendar that is limited to politics. I don't think their politics and their city duties should overlap. I think in that regard, I do think having the 2 calendars, while I think there was a negative connotation at our last meeting. I actually think that would be positive, so that the politics and the policy side don't blend. And I want to put that out to the board and take your guidance on. And then as far as the documenting any meetings before members, that would kind of fall under that same category. If somebody is meeting with a lobbyist, maybe they're having a political fundraiser for the reelection campaign, do we really want that to be documented through city business, or that'd be completely separate? And that was so that was the issue I didn't address in my draft, because I wanted to put that back before the board. Mr. Chairman, that's all I have at this time.
All right. Any questions on concerning the draft or the last issue that Mr. Reed just brought up concerning separate calendars, and should it be inclusive of any drafts that he revises for us?
Mr. Chairman,
Yes, sir.
I think John has done a nice job here. I think that the key distinction in my mind is you're not a lobbyist. Like, you're a human being. You can be a human being. You're always a human being. You're never not a human being. If you're a lobbyist, sometimes you're a lobbyist, sometimes you're a parent, sometimes you're an elder in your church, sometimes you're, you know, a home improvement bumbler. You can be many things. So if I'm a lobbyist and I come to try to persuade city officials to spend the public's money, then yes, I think that needs to be recorded somewhere. If I happen to be a lobbyist to make a living, but I come before the city commission to talk about paving the roads in my neighborhood, then I don't think I'm lobbying. I'm just there as a homeowner. And I think that the way John has got this laid out with the exceptions, we're looking at what is the communication rather than what is the person. What type of communication is it? So if I happen to lobby the city commission, but I also do some political consulting, and I meet with a city commissioner on their campaign, or I help them fundraise, I walk door to door, I'm not lobbying when I'm helping them on their campaign. That doesn't fit within the definition here of influencing the city official and how they are expending the public's money. It has to do with other things. And to me, as long as we keep that distinction separate, we're not invading on anybody's constitutional rights of freedom of speech or rights to petition government for redress of grievances. But at the same time, we are finding a way to reassure the public that those people who are trying to get public officials to spend our money that we pay in property taxes and utility fees and such, that there is some openness and some transparency in that. So that, let's say that I'm the government affairs person for a business. I'm not a lobbyist. I'm not I don't call myself a lobbyist. I call myself a government affairs person, or I call myself a business consultant. So right now I'm getting a pass on lobbying because I didn't apply that label to myself, and I got out of that catch-22 that John pointed out. A lobbyist is someone who lobbies. So if I claim that I don't lobby or that I'm not a lobbyist, then I'm not included. I think this goes a long way to what I perceive as something that would create a lot better feeling of transparency for members of this community.
Anyone else?
Mr. Chair,
Yes, Mr. Payne.
I would be interested in any maybe future public comment on this. I'm not sure if we've created more confusion as a lobbyist. The way it states now that a lobbyist is basically any person who is lobbying, whether paid or not, and that whether paid or not was always the simplest way that people could distinguish whether they're a lobbyist or not. So I'm just not sure that it will be clear to the public, and maybe it needs to be spelled out by the treasurer clerk or somebody, are we making his job more difficult in defining who is going to need to register as a lobbyist?
So I wanna make
Mr.
sure.
Chairman,
Okay. Yes.
along those lines, maybe we could put in something about where it's to a person's professional or occupational financial interests. Because again, if I own a business and I want the city to contract with my business, and so I go and I work over the city commissioners, am I lobbying? Well, I mean, I clearly have a huge financial stake in that, and I clearly want the public's money. But I might say, I'm not a lobbyist because I'm not being paid to lobby. I'm simply running my business. So to me, it's that financial piece that is exactly what Mr. Payne is getting at, but it's got to be loose enough that I'm not being separately paid just to approach a city commissioner, but it is in my personal pecuniary interest, business interest, to approach that city official. So somewhere there might be some words, a 4 or 5 word phrase that could fit in here. I think that would address that concern.
Right. Do you all want to take more time to have recommended language added, and then we can come back and look at that and make our decisions on that. And if I was hearing Mr. Payne correctly, he would also like for an opportunity for the public to be able to speak on this matter as well.
Yes, and I would also like some input from the Jim Cook, the treasurer clerk, to see, because it's his responsibility to take the lobbyist registration. So have some input there.
Oh, no, Ms. Graham.
I agree with all this discussion, and I do think we should look at putting some language that clarifies that. I also think we as lawyers can overthink this, and common sense wise, if it looks like a duck and quacks like a duck, it's probably a duck. And so I don't want to overcomplicate this. I think that public can ascertain whether or not someone's lobbying just by the nature of the conversation and what he or she hopes to get out of it. So I don't know. That's just my 2 cents. I don't want to make this so complicated that we lose sight of the common sense analysis of whether someone is actually going to have a financial benefit from the conversation they're having with an elected official or not.
And Mr. Chairman?
Yes, sir.
Along those lines, to me, the burden here is on the lobbyist or the person approaching the public official. If I'm a city God forbid, I will never be. If I were a city commissioner and someone came and talked to me about an issue, don't say it.
I know.
But if someone came and talked to me about an issue, I wouldn't know whether they had a pecuniary interest or whether someone was paying them. The burden needs to be on that person. And to the extent that there's a violation, and I think there already are in the city ordinances now, some penalties for violating the lobbyist registration provisions that currently exist. So the burden needs to be on that person to say, is this just my personal interest as a citizen of this community, as a resident of my neighborhood? Maybe I'm president of the homeowners association, but I also run a lobbying firm. When I'm there as president of the homeowners association, I'm not lobbying. But when I got a client, then I am. I'm the one who has to make that call. I don't want to say that we're going to call out city officials on this unless John can come up with some good language on how people keep their calendars, which I think would be great.
Yeah.
The burden, the label burden, needs to be on the person speaking to government, in my view.
Okay. Anyone else want to add to any of this?
So John, just draft up that language. Make it very clear, very simple, clear and simple.
Will do.
And I was going to also suggest if anyone had thoughts about any language, if they could maybe tender those to Mr. Reed. I would say maybe by June 2nd. What's that, 2 weeks from today? And if Mr. Floyd could reach out to the treasurer to get their insight or input concerning as Mr. Payne. I guess Mr. Payne had some questions for that individual. So maybe Mr. Floyd can reach out to garner that. All right, Mr. Reed, do you have anything else you want to add concerning that aspect of it?
No, I'm fine. Thank you.
All right. Anyone else before we move to the? Where are we right now? Where? What we have revision to bylaws.
Yes.
So section 7. All right.
Yes, so that is bylaw amendment 2020-03. This is the amendment that provides for public comment. This would create a limitation of 3 minutes for issues pertaining to the agenda, 1 minute for anything repetitious. At the last meeting, an amendment was proposed by Mr. Ray to change the word shall to may. And I have attached that as a traveling amendment so we could discuss it again separate from the language as you saw it at the last meeting. The reason being is that if you change the word shall to may, that puts 100% of the discretion into the hands of the chair. And this is something that probably should be a board decision. Now, of course, if it's not controversial, if somebody's there as our guest and speaking, it could be done through unanimous consent. We can move very quickly. So I don't think that being a board decision, which is if we keep the word shall, doesn't necessarily mean we have to bring the whole conversation, the comment to a halt, have a parliamentary or procedural vote, and then allow them to continue. We can roll it pretty quickly depending on the speaker. But I think that this makes it a board decision, so it doesn't give all of the discretion to the chair, which I think also takes a little pressure off the chair as well.
Any thoughts? Any comments?
Mr. Chairman? Oh.
Yes, you recognize Mr. Payne.
I just wanted to comment that I'm very much in favor of that amendment, to leave it to the discretion of the chair and make doesn't put as hard a limitation on things. That's all.
Mr. Chairman?
Yes, sir. You're recognized.
A slightly different issue. Now, particularly seeing what we're facing with online meetings. I get the 3 minutes and 1 minute if you've got a room full of people and people take the time to get to the mic and you start a clock. I'm a little concerned with technology and lag and the ability to always hear somebody, how good their mic is. If we may continue to meet like this for a while, I wonder if we need to extend that 1 minute and 3 minute to maybe 5, instead of 3 and 1, maybe 5 and 3 or 5 and 2, something so that we can accommodate just the technological glitches that seem to be occurring. I'll tell you, in a lot of my Zoom meetings where people can't talk over each other, you spend a lot of time, oh, you talk, no, you talk, oh, please, you. And you waste a lot of time going back and forth, whereas in a normal in-a-room meeting, multiple people can be talking and you can hear all of the conversations and you keep rolling along. It's just less efficient online, in my view.
I would tend to agree with that, thinking there should be some exceptions for any online compared to in person. I wouldn't have a problem with that, but would that be something we need to put in our document, though, or would that just be something a housekeeping tidbit to start the meeting if we're online?
Yeah, I agree with you, Mr. Chairman. We can keep the language in the bylaws, but then while we still have these online meetings, we can suspend them for this portion, because it won't make sense to update them to reflect the current situation, which may change in the next 2 months. So I think the idea of keeping the language, but then housekeeping it at the beginning of the meeting saying that the current time we're going to suspend the requirement of 3 minutes or the restriction of 3 minutes while we do these online meetings. I think that'd be a better course than actually changing the bylaws to reflect our current situation.
Yep, and then it'll be so much easier to control that online with the mute buttons and everything else that we have at our disposal. So yeah, I'm definitely I would say just leave the documents or make any changes for the documents' sake and not officially for online. But those are just my thoughts on it. Anyone else?
Okay, so Mr. Chairman, I would say at this time, since we do have a traveling amendment, the board should probably act on that, whether they want to do what we did at the last meeting, keep the language as it is. If you wanted to keep the word shall, then you would want to defeat the amendment to the amendment. If we wanted to go to the word may, we would adopt the traveling amendment. So I think that would be procedurally the way to move forward.
We have motions on the floor concerning this.
I move we accept the amendment with the amendment to the amendment.
Second that.
All right, it's been properly moved and seconded. Any unreadiness concerning this? All right, all in favor?
Aye.
Any opposed?
Aye.
All right, motion carries. So we will adopt this amendment to the amendment.
Mr. Chair,
Yes, sir.
just so I understand, because you all did a good job of keeping up with it, but what did you just do?
We adopted the traveling amendment and the amendment. So I will get you, I'll after this, we're done with the next one. If that's adopted, I'll redo the language and distribute it to the board.
It's going to be shall or may?
It's going to be shall. Or no, it's going to be may. Excuse me. It's going to be may.
Thank you.
All right, well, Mr. Reed, you can take us into the next one.
The next one is really no changes. This one I did put in. I think the only real issue we had that was different was if you look at line 22 and 24, or complaint was added. This was essentially, we wanted to make sure that issues that came through the hotline and complaints still stay within that confidential and exempt provision that's within statute, which is section 112.324. But besides those two small changes, there's really nothing different from the last meeting.
Okay. All right. Any discussion?
Mr. Chair, I'd move this amendment.
It's been moved. We have a second?
Second.
All right. All in favor?
Aye.
All right. Any
Aye.
opposed? All right, the motion carries. So I guess the same thing, Mr. Floyd, Mr. Reed will prepare it and have it ready for you.
Yes, sir.
All right. I guess that takes us to our next section, training update.
Thank you, Mr. Chairman. Very quickly, the section 2-14 of the city ordinance puts a great deal of emphasis on training, and the ethics officer is responsible for coordinating the training for what amounts to 3,000 plus employees. It is their responsibility, or my responsibility, to see that they receive ethics training on an annual basis, from the city officials to the kid doing work out on the softball field. It's a wide variation. It includes individuals who are running for election, and realistically, it's not something that I would try to do person to person for all 3,000 employees, but we're looking to do some online training in interacting, I think there are two main points I wanted to make. One of them is that the City of Tallahassee, the leadership, human resource development is working with us to coordinate, develop, and implement training. And even though I found that in a lot of cases they weren't familiar with the ordinance, but regardless, they're following the city ordinance, not only for following it, but they're actually exceeding what's required. And I just wanted to share that as an informational item.
Okay. Any questions of Mr. Floyd?
Okay, for agenda item 9, training ethical standards of conduct. When I came into this job, I understood that I was to do training, and what I found is that there was very little documentation of what was being taught. There is a class that's taught every month to new employees, but there wasn't a training curriculum or anything standardized. So what I'm attempting to do, and I'm doing this because I think this is a big part of the responsibility of the ethics board, and it should be better documented and perceived as a program and not just a responsibility that I am supposed to take care of. So what I'm bringing to you is it's a course that I developed with the help of the city attorney, Amy Tolman, quite a bit of assistance with input from Ben Wilcox and Peter Butson. This course was developed and delivered back in March. It was well received, and I could tell that the individuals in the class came out of the class understanding the ethics code. I'll tell you, when they were in the class, they went to statutes. They were very engaged in understanding the ethics code. And on the side of influencing behavior, then I think the training is very important. Bottom line is that I'm presenting this course, what I hope to be the first of many. This is Ethical Standards of Conduct course number 01. I'm asking the board to adopt it with an effective date of March 11, 2020 to coincide with the date that it was first taught.
Well, I do have a question for you. I see in the summary, conduct a post-test, which I guess would be an assessment piece. Has that been drafted yet, the assessment piece?
Not yet.
I would probably want to adopt it after seeing the assessment piece, and just have it all at one time, and so we can have any input on that as well, so we can gauge the effectiveness of it.
We can do that.
Mr. Chair,
Yes, sir.
I just wanted to applaud Mr. Floyd for his efforts here and the whole process of documenting training. I think it's a good outline that we're seeing here. Yeah, I would be interested in seeing the assessment part. I'm curious as to what he has in mind with additional courses. Can you just give kind of a broad overview of the kinds of things we might look to see in addition to this?
Sure. What I did was I've had a couple meetings with the city auditor, human resource development, a number of city attorney, a number of individuals. What I asked human resource to do is identify the kind of problems that they've seen come through their office. I've asked the city auditor to do the same thing. And from that, we culled information, very specific information on employee behavior from all the way from the top. And they introduced a phrase, simply tone at the top, how leadership leads, and how that behavior affects everybody else. And then it gets into employee behavior. I'm sorry, right off the top of my head, I can't give you specifics, but I do have it documented, so I can share it with you all if you wish.
Okay.
And to piggyback on Mr. Payne's comments, I really appreciate this and all the other things that you've been quickly implementing, especially during this time period, out of the office, going through pandemic and everything. And the work that you and Lucy have been doing is very evident. So I really appreciate that.
Thank you, Mr. Chair.
So any other comments pertaining to moving forward with this training update or adopt ethical standards?
I just want to concur with the comments about Mr. Floyd and Lucy. I want to thank you all for all the work you're doing, and looking forward to all the work we will do together in the future. So thank you both.
Thank you.
So do we have any motions on the floor concerning adopting this course or adding, I guess, what I recommended or suggested about the assessment piece first, or do you want to just adopt this now and then we can get the assessment piece later? That's up to you to discuss.
Mr. Chair, I'll withdraw my recommendation and bring it back with the suggestions that you all have.
Thank you.
Oh, okay. Thank you so much. All right. I guess that takes us now to Section 10, Board Attorney Compensation. Mr. Floyd, the floor is yours.
Yes, sir. On May 1st, 2019, the Independent Ethics Board entered into an agreement with Attorney Reed for legal services. The effective date of that contract was for February 7th, 2019 to September 30th, 2020. Unless terminated, the contract is automatically renewed for a 2-year term to coincide with the board's fiscal year. In addition, the agreement stipulates that for that period, Attorney Reed shall be compensated at a rate of $125 per hour. And I just want to point out that over the last year, because it started last May, so for the last year, we have received his services for cheap. At the same time, Attorney Tamayo was compensated at a rate of $200 per hour until she left. I also want to point out that we are currently compensating Attorney Menace at the rate of $250 per hour. By agreement between both parties, meaning Attorney Reed and the chair, the board did not convene on or negotiate the hourly rate back in September. It was put off, and I thought it appropriate to bring this to the board's attention so that it could be corrected. And $250 is a pretty standard rate. One of my attorney makes $500 an hour, by the way. And I told John, it's no way. But I think it is appropriate to recommend $250 per hour for the period May 19th, beginning today through 2020 to September 1st, 2021, when you all would review it again. So, Mr. Chair, that is my recommendation.
Any discussion on this matter?
Mr. Chairman?
Yes, Mr. Payne.
I'm just wondering if we need a new contract for approval, or if it's all right for a vote for this recommendation.
Mr. Floyd, how did you handle that administratively?
I believe that, and I know it's funny asking John to correct me if I'm wrong, but I believe that the contract allows for what this would be essentially be a renewal and a correction. Is that the best way to put it, John?
I think if as long as the board, I think, provides clear direction and authorizes the chair to execute the contract, which is, I think, what we did last time. I think the board said we're going to do during this time period, we're going to do this amount for myself, this amount for Ms. Tamayo, and based on those directions, we did just move forward to Mr. Herring. Mr. Herring signed it without it coming back to the board. If I may also offer one other issue, obviously Ms. Tamayo is now working for the Department of Juvenile Justice. So as my backup attorney, I have had the opportunity to work with Ms. Menace during our outside case, and we have developed a very good working relationship. She has agreed to serve as my backup attorney. So that wouldn't have to adjust her rates at all. That would be the same rate. And I don't expect that I'll have to use her very much as the backup attorney, but I think we've had a good relationship with her, and I'm glad that she was willing to accept that offer.
Any further discussion?
Mr. Chairman?
Yes, Mr. Herring.
I think we're talking, the way I see this, we're really talking about three distinct issues. One is we have always asked when we did our bid proposal for attorneys, we always asked to have a backup. And when Ms. Tamayo left, John didn't have a backup. So this would cover that backup issue. So that's one thing that needs to be addressed. A second is the extending the contract beyond the current contract expires September 30, 2020. So however long that is, a few months from now.
Okay.
And the third issue is the hourly compensation under the current contract that expires September 30, 2020. I will tell, and I'm not, I don't know that we need to handle all three of them separately, but I think we ought to just be aware that we do have three separate issues before us. I will tell you, this is one of the things that I got phone calls on that people from the Ethics Coalition said that if we were in a normal public meeting in a room, that they would want to get up and comment on this. And they said they would, before we take a final action, they said to me that they would like to have the opportunity to comment. One of them did point out that the proposal from, I think that was on the board agenda in February of 2019. Yeah, February 2019. Said $125 an hour, and they were, I'm not sure what the right word is, nonplussed maybe. They wanted to be able to comment on changing it during the current contract period. So I'm conveying that message, that bit of public input. So those would be my comments.
Any comments, Mr. Ray? Did I see your hand go up?
I will say,
No.
Carlos, you go first.
Just as far as the compensation, how is that in line with our previous expenses for outside attorneys? I know I came on board as soon as we hired Mr. Reed. Is this $250 in line with what we paid previous attorneys or previous practices?
Mr. Herring?
Yeah, I don't remember the exact figure, but our longest serving board attorney was Mr. Currington, and it was in that range. I don't remember exactly, but it was close to that amount. I will say, when we did the selection of the new board attorney last winter of 2019, early 2019, we weighted all of the elements, the experience, background, knowledge, expertise, all that stuff. And I will say that we gave 10% of the total score, because we actually scored all of we had about 6 different applications. We gave 10% of the score to their hourly rate. So we did not put a lot of focus on the hourly rate. And I remember there were several board members who said at that time, we weren't as concerned with what we had to pay the attorney per hour as we were that we got the right person with the right background and the right expertise. So that would provide a little bit of context that both in terms of what Mr. Currington was making, and then there was an attorney between Mr. Currington and Mr. Reed, and I think she also was making in the mid 200s an hour, or maybe 220, 250, somewhere in that range per hour.
Mr. Chair,
Thank you.
Mr. Floyd.
Is Mr. Floyd speaking?
Floyd is muted, I believe.
you can't hear me?
No, we didn't hear you.
Okay, can everybody hear me now?
Yes, sir.
Okay. Ms. Graham, can you hear me? Okay. We pulled our records. Gerald Currington was paid $275. Partners was paid $275. Associates was paid $275. Excuse me, $175. And a paralegal was paid almost as much what John's making now, which is $100. And that was 2017.
I'd like to comment. First, I think Mr. Reed is doing an excellent job. I believe that he has given us good counsel. He's always available. I am very pleased with all of the work he has done for this board. That being said, as Richard leaves, I do think that the expenditure of funds is one of the most important public trusts that we have, because they're not our dollars, they're the taxpayers' dollars. So I understand the concern that Mr. Herring brought up, that we don't have an opportunity to have the public comment before we ultimately either vote this up or down. And I'm not sure if we can, if we're not able to go back to live meetings before our next meeting, if there's some way that we could do what we talked about at the beginning of this meeting and have an opportunity for public comment during our virtual meetings or not. But given that this is something that I think would be an issue that people would wish to comment on, that it would only be in the best interest of our commitment to the citizens of Tallahassee that we have the opportunity for public comment before we reach a final decision. And again, this has nothing to do with Mr. Reed's able service as the board attorney. I'm very pleased with all he's done since he's been part of our happy team here. Hi, Rich. Hi, Mr. Herring. Unmute.
I was listening, but
No, that's okay. That's okay. I was just commenting that I felt that because this is the expenditure of the public dollar, that we do owe it to the citizens of Tallahassee who might wish to comment, to give them that opportunity before we reached a final up or down vote on this. And of course, this has nothing to do with Mr. Reed's capable guidance and counsel that he's been providing. I just think it's more that we have to be aware that this could create some level of questions and controversy, that we want to have the public have a chance to make those comments before we vote, as opposed to having the vote and then facing what could be some backlash.
Mr. Chair.
Mr. Fain?
I agree with Ms. Graham's concerns about offering public comment. I will point out that this was part of our agenda, our published agenda, and people did have opportunity for public comment. Mr. Butzine obviously read the agenda carefully and offered a couple of comments, and I'm sure he would have commented on that if he had a concern. Not put words in his mouth, but I understand the need to give people every opportunity to comment, given that we're talking about doubling the fee. But just to point out that people did have some some opportunity.
Mr.
Chair.
Chairman, not that it's particularly relevant to these particular comments, but along the attaboy line, I would point out that when Mr. Reed started with the board, we were finishing up our blue sky list, which meant drafting all of the proposed ordinances that we sent to the city commission. So in terms of getting work done cheaply, there was a huge mountain to climb when he first came on board in terms of workload, and I don't know that we will, in any time in the near future, expect to put that kind of work on our board attorney, but we certainly got our money's worth in his first few months.
Yeah, so I just want to reemphasize that, in my opinion, this has nothing to do with Mr. Reed's able counsel and service to this board. It is more that I could see a potential of concern from the public, and I understand Mr. Payne's comments as well, but it appears that that the citizens of Tallahassee reached out to you, Richard, and that you've conveyed their concerns during this board meeting. I don't know. It's just, I mean, I'm just saying that I could foresee some issues that we could avoid by just postponing this until the next meeting, and that we have the opportunity to get public comment either virtually during the meeting, or maybe, I don't think so, but maybe we could be back in a live setting, but I mean, a face-to-face setting. I doubt it, but I will go with the will of the board. I'm just expressing what I think we could avoid by allowing that opportunity for public comment.
Mr. Chair,
Yes.
just want to, it looks like we didn't include the contract with the agenda item, and I meant to, and in answering, one thing I want to point out to make sure I'm communicated clearly, and it's not to change your decision one way or the other. But in the contract, it said for the period of February 7th through September 30th, they would compensate the Attorney Reed at $125, and that was supposed to be up to September 30th, 2019. So we're here 9 months later. It says the party shall convene no later than September 1st, and that was supposed to be up 2019, and that didn't happen. So that is something that this board agreed to, and I just wanted to point out to the board. That's why I used the term correct, making a correction because it was something that should have happened 9 months ago.
Mr. Chairman, if I may.
Yes, Mr. Reed.
Yeah, just to make one quick clarification, we did actually convene last August, September, pursuant to the contract, and we made a conscious decision to put it off until the new year. During that time, we were just been served papers in litigation. We were transitioning to a new ethics officer. We're interviewing for a new ethics officer, which obviously was not something we could foresee at the time we entered into the contract. So I just wanted to make it clear that I did bring it to the board's attention in September, and Mr. Herring and I reached a mutual agreement that we would, because there was so much going on at that time, we didn't want to overwhelm the board, and I said I was willing to sit back and wait until the new year. We originally talked about bringing it back in March, but then March and April were canceled, so this was the first opportunity. So I just wanted to clarify that we did convene. We just made a conscious decision to wait so that some of the fireworks that we were going through at the time would pass. Also, I think it's important to point out the contract would not adjust the total cap on what I'm to be paid. It would just affect the hourly rate. So once I reach that cap, I would be done. I'm not looking to increase that amount. So it wouldn't affect the budget.
I appreciate that. And to Mr. Payne and Mr. Floyd's point, looking back at the board docs, this is listed and the copy of the contract. So I kind of lean towards individuals had an opportunity to address it, even though I know some are probably more comfortable addressing it, verbally instead of writing down their concerns. So I guess the question would be, do we move along with the scheduled agenda and the points that we have addressed, or is there a motion to table it to the next meeting and address this issue? So individuals could, I guess, have an opportunity to either write it or verbalize it if we have the, since we expect to have the capacity to allow citizens to join us.
In my opinion, Mr. Chair, I do believe we should table this in an abundance of caution, that we not be faced with some concerns that we have voted to expend additional taxpayer dollars. And I appreciate, John, that you said this is not going to be, that your cap would remain the same. So, but again, it's just my feeling that we should give the public an opportunity to make comments. And I'm not saying that that's going to change my opinion about whether or not I vote up or down on this, or maybe we move to have a different dollar amount. I don't know, but I still would feel more comfortable having the opportunity to hear public comment before we take a vote. But again, that's my opinion. I think the will of the board should prevail, and if you all wish to move forward and vote, then I respect that motion as well.
Mr. Chairman,
Mr. Herring?
my suggestion would be that we put off the final decision until our next board meeting, but that if we change the rate of compensation to whatever amount, it be retroactive to the date of this board meeting, so that kind of splits the baby. But that we also split two issues, that we deal with the issue of adding the backup attorney and the rate of compensation as one vote, and we deal with the issue of extending the contract beyond September 30, 2020 as a second vote, so that we don't get we're not rolling quite so many issues up into one big ball.
Okay. So you want to put that into a motion for us?
I move.
Yeah, right. All right. So, all right. So it's been moved.
So moved, and I think that's a brilliant compromise, Mr. Herring.
All right. So it's been moved to table the final decision on the compensation until the next board meeting. And at that time, the issue of choosing or approving a backup attorney, as well as extending the contract past September 30th, 2020, will be addressed.
And the addition to that, that any decision that is reached at our next board meeting will be retroactive to today's board meeting.
All right. Okay.
Right. So that would relate to Mr. Reed's compensation. And of course, the backup attorney, we also will need to address the backup attorney's compensation. But I would assume that it would be similar to Mr. Reed's. I think what Mr. Floyd proposed for our current contract attorney would be the same rate that she's charging to represent us in the litigation.
Okay. All right. All right. So I guess I'll take this to vote. All in favor of Mr. Herring's motion as amended?
Aye.
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 All right. Any opposed? All right. It carries.
Thank you.
All right.
And Mr. Chairman, I do want to say that John was absolutely correct in what he told you. He and I discussed this issue a number of times, that it was something under the current contract that was supposed to have come up at the end of last year. And it was actually at Mr. Reed's suggestion, not mine, that he said, let's just not do this right now. The board is facing some unanticipated and unknown expenditures, and to his credit, he did not want to put us in a position of talking about spending more money when we didn't really know where we were. So we are where we are because of Mr. Reed's good judgment.
I really appreciate that. All right, at this point, we'll move forward to the Ethics Office audit report by an outside agency. And Mr. Floyd, you have the floor. You're on mute, sir.
I'm sorry, I was talking to myself. In December 2019, the Ethics Board hired the Moore Stephen Lovelace PA to conduct an audit of expenditures for the board, covering the period March 1st, 2015 through September 30th, 2019. The purpose was to determine that the expenditures of the board comply with applicable state statutes, city ordinances, and city policies and procedures. The audit was completed, and you all have a copy of the summary. There were no findings. There were not any findings of noncompliance. However, the auditor did make 3 recommendations that he actually visited our office and we discussed. He recommended the board provide additional oversight on expenditures made by the ethics officer. And basically what he noted is that I approve purchases made by the administrative specialist, Lucy, and she in turn approves the expenditures that I make. I will note that his recommendations is that the board review these monthly, and in the budget report that was given to you today, I tried to make it explicitly clear what we have spent since the last meeting, and that was my way of dealing with that one. Secondly, it was recommended that the P card transactions be documented on the receipt, and he gave food as an example. We've changed our practices to meet that recommendation. And it was also noted that I approve Lucy's timesheet, she approves mine. The timesheet closed out on a Friday. They asked us to approve timesheets that Friday. We generally have until noon the following Monday to approve timesheets. But those were the primary recommendations made by the audit.
Do we have any discussion pertaining to the recommendations or the audit?
Mr. Chairman, I guess I have one thought.
Okay.
I think a number of us were taken aback some months ago when we learned how the different elements that we had paid, the board had paid for in the way of dues to various organizations. And the board did take some action on that, kind of retroactively. But I think it would be in line with what the auditor has said and very appropriate to have a member of the board who actually goes through the details of expenditures for anything that is discretionary. I know, like in state agencies, if you're going to travel, your travel gets looked at 9 ways from Sunday because they're very tight on that stuff. Whereas when you go out and buy a new case of paper, nobody much cares because that's routine office expense. So I think to have a member of the board in that loop, just regular, and I know Lucy is great when, several times she's walked me through elements of the budget, and she has a tremendous background in that stuff and can do it in her sleep and explain everything. But so that we don't ever get caught in a situation like we did once before, I think it would be very good to have a member of the board formally in that role as kind of a subcommittee of one, just looking at things. I like the report that Mr. Floyd gave today. I thought that was more detail and very helpful, and we should continue to do that. But having a board member directly involved, and I don't think it would be more than maybe a 15 or 20-minute phone call once a month. So it shouldn't be burdensome. I think would be right in line with what the auditor said.
Mr. Chair,
Sir.
I agree with what Mr. Herring is saying. It would probably be most appropriate for the chair to be in that role. I'm not sure if I want to throw that on you necessarily, but rather than a phone call, though, I think it should be in a written approval. Email should be sufficient, since that's public record. Just a quick email for any expenditures, and just a quick approval from the board representative.
Yeah, I can take that on.
We appreciate it.
Yeah, and I think Lucy has a good idea. I'm hoping she'll nod at me at some point here that she can say, well, if it's a box of pens or a box of yellow highlighters, I'm not going to list that out separately. But if it's travel, if it's reimbursement for something that's not routine, if it's dues for some organization, then I'm going to go ahead and list that so that the chair gets to see it, and he can see how we're spending, even if it's a matter of $100, $200, just so that the public is always confident that, because ultimately it is their money, that we're spending that money in a way that they would approve.
Anyone else want to add to this discussion? All right. That be something we need to vote on, or that would just be an administrative function that add to the plate?
I think we ought to move that going forward, that any expenses are approved via email by the chair, or however you want to do that.
Could we amend that to reviewed or approved? Because there might be a situation where Mr. Floyd pretty much, something comes in from the city and he has to spend the money, and the chair's not, or whichever member of the board's not available, but that's somebody as quickly as possible is looking at it.
I would accept that amendment.
All right. Well, it's been moved. Do I have a second?
Second, Ruby Barr, seconds.
All right. Been properly moved and second. All in favor?
Aye.
Aye.
All right. Any opposed? All right. Well, that passes. Where are we now? Anything else you want to add to that, Mr. Floyd, before we move to the selection?
No, sir. I think that's good. I'm actually more comfortable with oversight than not. So that's good.
All right. Okay. We'll now move into section number 12, selection of at-large board member. We've delayed this. Give everyone time to review applications. Do we have any questions concerning any of the applications or candidates? Do we have any discussion? Yes, Ms. Graham.
I'd just like to say, before we start discussing, I believe, very capable individuals who wish to serve on this board, that we have talked quite frequently about the need for diversity on the board. And so in that regard, I have looked very closely at the women that have applied. We are replacing a woman that term limited off the board, God bless her, with, I think, in my opinion, I would like to see a woman appointed, but so because of that. So I just wanted to say that up front. No disrespect to the men who have applied, but I'm looking very closely at the women candidates for that reason. We need diversity, and Ms. Barr and I are holding it down. We we'd like to have a third woman on the board as well. So,
Mr. Chair,
Yes, sir.
unfortunately, just before we started the meeting, we've been made aware that there is one applicant, Julie Taylor Fisher. We checked with the Leon County property appraisers, and her house is actually in the county tax district rather than the city tax district. I've called her and made her aware and informed her that I would have to make the board aware.
Okay, all right.
And Mr. Chairman,
Yes, sir.
this is the second issue on which I got a phone call, actually a couple phone calls. And it's not specifically about any of these people, but there is continued interest, I would say, from the advocacy community that the board come up with some kind of a, not a job description, but a more direction, that when we advertise a vacancy, we not just say anybody who's interested, send us something, but that we have some criteria for what we'd like to see in terms of background and experience, somebody with investigative background or ethics background or something specific. And that would be kind of in line with Mr. Butzin's comments, where he thought that while we got some very standout citizens, we don't necessarily have everyone on the group with a background specifically related to this board's work.
Anyone else like to add to it?
Just a clarification, is Mr. Herring moving that we postpone the appointment, or?
No, sir. I'm saying we might think about putting on I'm sorry, Mr. Chairman.
Yes, you recognize.
We might consider putting on a future agenda what we would like to see. I mean, we can't require anything because obviously the charter says what the various gives power to the various appointing authorities. So the president of FAMU cannot be told, I don't think we can tell the president of FAMU, you must appoint someone with, specifically with 3 years background doing ethics, although that's what we got. But I don't think we can impose that because I think the charter sets it, but we could have guidelines for what we would like to see in terms of whatever backgrounds we think are useful: investigative, law enforcement, auditing, ethics, any of those kinds of things, just as I think some guidelines that we might talk about and agree on. It would be a reasonable exercise for the board to go through. And I know for when I go in a couple months and write a letter to my appointing authority reminding him that he's got to appoint my replacement, if the board had guidance for him, I know that he would take that guidance very seriously.
All right. How do you all want to have start the discussion on various candidates or applicants that you found interesting?
well, Mr. Chairman, can we move to have Mr. Herring's term extended?
I think it's in the city ordinance.
Well, details. Of course, Miss Taylor Fisher was one of my top 3. So some of these individuals have been before the board previously, and I'm happy. I would like to hear others' comments on any of the candidates if you wish, but I also would be willing to move forward with my top 3, and maybe that's a way we can kind of see where we have consensus. Your call, Mr. Chairman, though.
If people want to have discussion, I'm all in favor of that. But I'm also, especially, I find it more efficient to go ahead and have your top 1 through or 3. However, I had a top one, and I just got that news from Mr. Floyd, so that take me back to the drawing board now. But I'm interested to hear everyone else's.
Sure.
Sir.
I believe in the past, my memory that we've each given us our top three or something like that,
Yes, sir.
and then narrowed it down to the common names and voted on that. So if it's all right with you, I think we ought to move forward that with each of us giving the top three and move forward that way.
Okay, I'm with that. You want to start us off?
Sure. My top three would be Kristen Costa, William McDaniel, John Clark.
Okay. Ms. Graham?
Sure. My top three are Kristen Costa, David Alcorn, and John Clark. Those are not in any order, though I would put Kristen because of being a woman. I would, and I think we need the diversity on the board. We've talked about this a lot. She would be my first choice. Sorry to the men out there, but we need more women on the board.
All right. Ms. Barr?
All right. Same three as Gwen.
Order?
Of course, the woman first.
Oh, okay. And then Alcorn and Clark?
Doesn't matter.
All right, Mr. Ray?
The David Alcorn, William DeAngelis, and Willie McDaniel.
And your second again was DeAngelis? All right, Mr. Herring? You're on mute. Yeah.
Sorry, I forget to click that. I had Ms. Taylor Fisher on my list, so I'm sort of adjusting here. I will disclose I know Mr. McDaniel and professionally, and think very highly of him, so he would make my list. Mr. Is it Oliveira? I think it is, who worked for the Attorney General, would be on my list. Mr. Alcorn would be on my list, and Ms. Costa would be on my list. So I guess I have 4.
So that was, okay, Vela. Costa.
Alcorn.
And you had
McDaniel.
I want to disclose as well that I do, Mr. Chair, that I know Ms. Costa. Mrs. Costa, I've known her for a very long time. I think she's a person of great character and great integrity. Her background in Tallahassee, she has a lot of good work that she's done in Tallahassee, particularly in the healthcare field. She's a registered nurse. So I want to disclose that as well. She happens to be the woman candidate. Unfortunately, Miss Taylor Fisher is not qualified because she doesn't live in the city limits. But in full disclosure, just wanted to let you all know that as well.
Okay. And I had initially Taylor Fisher, but after that I had McDaniel. I think I had Costa. Well, those were my 3. I didn't even look at the 4th one. So I guess with Taylor Fisher gone, that leaves me with McDaniel and Costa. So I guess you all gave me your names in order. So C3 for Costa as the first choice, 2 for McDaniel, and 1 for Alcorn. So what are your thoughts on that as first choices?
Mr. Chairman, mine were not in any particular order. I do want to go back and say that I think any of these people would do well. The other woman candidate was Miss Potter, who's a retired teacher, who I think would do just a fine job on the board. So the fact that we didn't, I want to make it clear from my perspective, the fact that we didn't name somebody is no slight whatsoever. And I applaud all of these people for coming forward and volunteering for this particular duty, because it's not always, while you all are always very pleasant, the experience is not always the most fun I've ever had.
Okay, so if you didn't have it in any particular order,
I think maybe we go with Miss Costa. I mean, I would be fine with that, but particularly if it keeps Miss Graham and Miss Barr happy, then I'm all about that.
okay. Anyone else?
I would second that if that's a motion.
Hey, Richard, could you come talk to my husband a little bit?
Sure, I'd be
You don't have to
happy
comment.
to.
You do not have to comment.
Mr. Ray?
You do not have to comment. And again, just want, again, and I think any of these candidates would be great. And I was particularly impressed with Mr. Alcorn's experience. He was an inspector general. So, but I do think that for diversity's sake, that Miss Costa would be a fabulous selection.
Mr. Ray, I saw your hand up, I thought.
Am I in order? So I'll go with the will of the board. If we're going to Costa, Costa it is.
All right, so is that what the board is proposing?
I want to give a shout out to John Clark. I spoke highly about him at a previous meeting. He's a wonderful member of our community. And again, great people. So this is no negative comment on any of them. They just, in my opinion, don't meet the one quality I'm looking for, the diversity and having another woman on the board. So, and I know Ms. Costa would be a fabulous member.
So do we have a motion in front of us?
I believe Mr. Herring moved, and I second it.
Oh, okay. All right.
I'll turn my comment into a motion, because I think Ms. Costa was named by, not necessarily in order. First preference was on more lists than any other single person.
I would count, including mine. I would count Ms. Costa, 3 for Mr. Clark, 2 for Mr. Alcorn. So yeah, Costa would have the most. Yeah. So, all right. I guess you all at this time we'll take it to a vote. All in favor of Mr. Herring's motion to select and offer the position to Ms. Costa?
Aye.
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 Any opposed? All right, it passes. So I guess I will get with Mr. Floyd and we will make a communication to Ms. Costa. And if she still wants to accept this position, and we'll move forward from there. All right. At this time, we'll move to section 13. And that would be any discussions from members regarding items desired for future agendas. And I have a note here that Mr. Payne would like to discuss member involvement in activities outside of the ethics board. agendas.
Yes,
Mr. Payne?
Mr. Chair, I request this item be added to the agenda because of an incident that occurred at the March 11 City Commission meeting. A discussion took place between Mayor Daley and myself, which brought up an issue regarding the propriety of an ethics board member offering public comment at City Commission meetings. I felt that the board should be made aware of it and given a chance to comment. By way of background, I'd like to remind the board of a discussion that took place a year ago at the May 21st, 2019 meeting of the Independent Ethics Board. Then Chairman Herring had suggested an amendment to the bylaws regarding ex parte communication. Prior to this amendment, our bylaws stated that no member of the board could engage in any conversation with city officials regarding any item which could conceivably come before the board. Mr. Herring suggested limiting this prohibition to specific conversations regarding ethics code violations or complaints that had or may come before the board while acting in our quasi-judiciary capacity. The board agreed to the amendment and it was implemented. I'd asked for a clarification and expansion on this at that meeting, since I've made a regular habit of attending city commission meetings, occasionally speaking both publicly and informally with commissioners before, during, and after meetings. I've been doing this before I was ever appointed to the ethics board and continue to do so after, though never relating to specific, actual, or potential ethics code violations. In fact, I believe it was primarily because of my involvement and concern with city commission activities that led to my appointment to the board by the city commission. It was agreed that Mr. Herring's amendment would put me back in compliance, and in fact, he encouraged me to continue such activities. Jump forward to the February 12, 2020 City Commission meeting, at which City Treasurer Clerk Jim Cook laid out the possible ways to approach a city charter review. Mayor Daley supported pursuing a charter review, but commented that he would want any output of the review that would be put before the voters to be comprehensive and not done in a piecemeal approach, as he put it. Although I agree with most of what he said, the words he used reminded me of the output of the Florida Constitutional Review Committee in 2018, which forced the voters to make proposed amendments on disparate topics that have been arbitrarily lumped together. I felt that this was irresponsible of the CRC and wanted to caution the City Commission not to make the same mistake. Since my comments would be on a policy decision to be made by the City Commission, and the topic didn't appear to me to be remotely connected to ethics at all, and certainly to any specific ethics violation or complaint, I didn't feel there was any conflict here. The next opportunity I had to comment on this publicly was at the March 11 City Commission meeting. Because my comments were a reaction to the mayor's words, I quoted him directly, attributing the words to him, and in fact spoke directly to him. Apparently he took offense at that and stated in the public meeting that he felt it was inappropriate for a member of the Independent Ethics Board to speak critically in public of something he had said, calling him out by name, as he put it. Since I was a member of a body that had quasi-judicial jurisdiction over him, he felt that any disagreement we had could compromise my objectivity in the future if faced with possible ethics complaint. He said there was no way that I could separate myself or anything I said from my position on the ethics board, any more than he could separate himself from his position as mayor. After the meeting, I attempted privately to explain to the mayor I had intended no direct attack on him personally, but that I did disagree with him regarding the propriety of my speaking in a public forum. I described the situation to Mr. Floyd just to get his opinion. He suggested that it would be more appropriate to bring it to the board as a whole, and I agreed. It's also my understanding that Chairman Smith and Mr. Floyd had a subsequent meeting with the mayor at which this issue was brought up. I apologize for taking so much time on this, but I wanted to provide this background to you and solicit any opinions that you all have on this. Each has a strong concern about the way city government is managed. I don't believe our personal concern is limited to the ethics sphere, but also relates to such things as efficiency of operations. If the Consensus is that board members should refrain from any discussion of policy issues with city officials, regardless of their relevance to the Tallahassee Ethics Code. I would think that a vote should be taken, perhaps at our next meeting, as to whether to amend our bylaws to reflect that. However, I personally would have serious reservations to this action based on the First Amendment. Thank you all for your indulgence, and I yield the floor.
Mr. Chairman,
Mr. Herring.
I would be fully supportive of Mr. Payne, and I have several thoughts. One is we want to encourage people to be on, people particularly who are involved and concerned with the community, to be on the board. Those are exactly the kind of people who might have concerns about how government is run on a number of topics that aren't specific to ethics. The issue of bundling unrelated public policies to put before the voters, to me, is not one. I don't know how you could turn that into an ethics related issue. It simply is not ethics. It is a way that government sometimes puts issues before the voters. Our Constitution wisely says the legislature cannot do that in passing legislation through the single subject provision of Article 3, Section 6, and even the single subject as it relates to the budget provisions of Article 3, Section 12. So I think that this idea of distinguishing topics is something that is not difficult to do. If a member of the board had a concern that a city official was taking money in order to submit a proposal, I would think that would not be something that the board member would stand up and comment on in a public meeting, because that specifically could turn into an ethics issue. But what Mr. Payne was doing, in my mind, is about as far from improper ethics types of things as you can get. So I'm not only supportive of what he did, but I like our bylaw the way it's written. I think that all of us, it falls right within Ms. Graham's, if it walks like a duck and quacks like a duck and poops like a duck, then it's a duck. And Mr. Payne is simply not a duck. So that's my comment.
Thank you for that.
Anyone else have any comments?
I'm trying to think what kind of bird Mr. Payne would be.
Let's not discuss that.
Thank you, Mr. Herring. Thank you, Mr. Payne. I agree. Common sense needs to apply.
Anyone else?
I would be curious if you could, what the content of the discussion with the mayor was that you and Mr. Floyd had.
Okay.
If it's appropriate to say that.
It's pretty much how you outlined it. Almost verbatim, whatever the discussion that you and the mayor had, how he felt that it could be. I guess the concern is that if anyone on the board does not agree, then or people on the commission or the mayor, anyone on our purview doesn't agree with how we view things individually or collectively, it could be then used against them with, I guess, the powers that we have as the ethics board. I don't know, it could have been a bad taste left from interactions with our last ethics officer. So that's how I perceived it. I do know, and I can just speak to myself, I do try to avoid having comments with things because I don't want to give the slightest impression that I would be unbiased should someone have to come in front of us. It's a very thin line that we have to walk with that. Concerned citizen, as you stated, you've been a concerned citizen way before your time on the board. and is that realistic to cut that off just because you get on this board? So I kind of see both sides. I don't know how do we navigate that as ethics board members, because I don't want to give the impression that we're not independent or that we could be unbiased in any particular way. So I don't know if it was that necessarily that particular issue that was concerning or alarming, or is it the potential of something becoming an issue down the road, should they be in front of us. So that's what that was my takeaway from the discussion.
Mr. Chair,
Yes, sir.
I would be the first if the issue of bundling issues for a charter amendment somehow became an ethics issue and came before this board. I will be the first one, assuming I'm still on the board at that point, to say that Mr. Payne needs to recuse himself. So that's the easy solution to any of us if we make a judgment call that in hindsight turns out to not have worked out. But what Mr. Payne was doing is in a much broader sense exactly in line with what this board is supposed to be about, and that is offering some assurance to the public in this community that government is operating transparently and in their best interest. So not bundling issues for a charter amendment, to me, while it does not overlap with ethics, it is consistent with the idea of all of the ethics regulations that try to make sure that government is spending money in a way that appropriately and adequately represents the interests of the community and the people whose money it ultimately was or is. I think recusal is the obvious answer, that, and any of us puts ourselves in that position, just like any judge who, of course, they're full-time employees too, but any judge who ever speaks on any issue puts themselves in a position ultimately of potentially having to recuse themselves. Judges who serve on boards or who serve in community service organizations routinely do recuse themselves when there tends to be some overlap with their jobs. It's not difficult to find that solution.
Mr. Chair.
Yes, sir.
I agree with Mr. Herring. I would have absolutely no problem recusing myself if this issue were to come up as an ethics complaint. It would be fairly obvious at that point that I should recuse myself in that regard. The bylaws, it did state anything that could come, or could possibly come, but it currently states specific to the ethics code and violations thereof, potential violations. But I think the recusal option is a good solution, and I'm stand ready to do that if that issue were to come before the board at all. I also point out that I am an appointee of the city commission, and they of course have the ability to withdraw the appointment, or certainly not reappoint me when my term comes up. That's up to a vote of all 5 of the city commission, of course. But that only applies to me, of course. Our rules should apply to the board as a whole.
And I would also say I don't think any of us should be hamstrung by past interactions of ethics officer or past or former board members or anything. We're all individuals. This is a new board. I think we're all moving in the same direction. Sometimes we may take different paths to get to that same destination, but I think we all move toward the same destination. And I don't want to feel as if we have to always have that around our neck, like an albatross, of any negative interactions that individuals throughout who we may have a jurisdiction over may have had with past boards or past board officers. So I mean, recusal sounds fine for me in anything. If that's an issue, I was just giving you my takeaway from why the feelings may have been frayed.
Thank you. I don't know if there's anything that's needed of us at this point, unless anybody wants to suggest another revision to the bylaws, but I think those who have spoken have not indicated that.
Yeah, I don't see where that would be necessary at this time. You know, if something becomes an issue, I say we address that at that time. Right now, I don't see where it was that big of a deal. You know, I respect the mayor for expressing his concerns. I respect your thoughts on it, and that's just how I look at it. You know, people won't always agree on a particular action, and that to me, that's just two individuals with two different interpretations of that singular act, and I don't think that warrants any change or amendment to the bylaws.
Thank you.
Anyone else have any comments about that? Any other issues they'd like to have addressed at the next meeting? All right.
I just want to confirm that I have Googled it and a duck is indeed a bird. I was not
All
sure.
right. All right.
How to know.
Okay. Well, I think we'll move on to directives. I think we have our task, the assessment, if memory serves me, the assessment piece for the training. Mr. Reed has his amendments to his which piece was that? I forgot. Mine's going bad now. We'll also be tabling. We decided to table the compensation until the next meeting, and address those multiple issues concerning that. If anyone wants to contribute to that amendment that Mr. Reed is working on, they have until June 2nd to submit. And I think that was it, and unless I'm missing something else. Well, I guess it's time. I'll take any motions to adjourn. Oh, but before that, I guess I'd like to say, continue to take care. I hope everyone has been doing well under these circumstances that we find ourselves now. Look forward to seeing you all next month. Be good to see you in person again soon. I don't know when that may be. And you all take care, and I hope your families are doing well. So at this point, I'll take any motion to adjourn.
I believe Gwen wants to say something.
Okay, Ms. Graham.
That was just my motion to adjourn.
Oh, okay. All right. All right.
Thank you all.
Properly moved. All right, so moved. So you all take care, and we are officially adjourned, and it is 6:11 p.m.